I have a client that's in the middle of a divorce and wants to do a will. In the will, she would like to disinherit her husband and leave all of her assets to her two children. The mutual two children, right? With the husband that she's in the middle of getting a divorce with. New York State does not allow you to disinherit a spouse. Not actually. So in the will, we can place a term that says I am something like this, right? From my head. I'm specifically disinheriting my spouse. I'm in the middle of a divorce. Little line there. Now, it's up to the husband, in the event that she passed away before the divorce is over. She'd be married. The divorce would be abated by death. And he could, in theory, in actuality, actually, let me say it that way, he could exercise a right of election. And that means he can inherit as if there was no will. So in that instance, if the divorce was not finalized and my client passed away, the husband would receive, and if he exercised his right of election, he would receive the first $50,000 and 50% of whatever remains. Now, if they were married, it may in fact be that a lot of their assets are joint, or the property, or a bank account. There might be many joint assets, and therefore he would get all of those assets by operation of law automatically. But any individually owned asset from that separate pool of perhaps separate property, if he exercised the right of election, he would in fact be entitled to it. What should we do? Well, let's try it and see what happens. Maybe, hopefully, probably, she will live for many decades after the divorce. And the will prepared now will be moot